Hello, my name is Gregory Alexanyan, and I'm an attorney with practices in the Southern California region. Today's clip will be dedicated to the effect of criminal convictions on a naturalization application. As you may know, having been a lawful permanent resident for a period of 5 years, makes a person eligible to apply for citizenship or naturalization in the United States. 5 years is applicable to the majority of the green card holders, and in some situations the waiting period before someone can apply for citizenship can be 3 years, and typically these are the situations when the person obtained their green card through marriage or through military service. So once the time has come to apply for citizenship and there is a need to determine whether a application should be filed or not, one of the considerations should be the good moral character of the person during the statutory period, which is the 5-year or 3-year period, depending on how the person obtained the green card. Because depending on whether there was a good moral character or not, the application will be denied or approved by the immigration officer. Good moral character is determined primarily based on the criminal record of the individual. There are certain provisions that relate to unlawful acts, which we will discuss later, but primarily that determination of good moral character is made on based on criminal convictions of an individual. So there are two types of convictions. They may result in permanent bar and conditional bar on establishing good moral character for the statutory period. Permanent bars will result from convictions that include very grave criminal offenses, which include, of course, murder. The list includes also rape, sexual abuse of a minor, illicit trafficking of substance, trafficking in firearms or destructive devices, money laundering offenses over $10,000, crimes of violence which result in a 1-year sentence, child pornography, prostitution offenses, namely managing, transporting, and trafficking of prostitutes, espionage charges, alien smuggling, and the list goes on. So these permanent bars do not allow an individual to obtain citizenship in the United States, period. Well, to be more specific, if these crimes or the convictions were resulted after 1990. Convictions for these enumerated crimes that resulted before 1990, they may be excused in very, very rare situations where the officer or the applicant can show that there has been rehabilitation, that the crime was not during this statutory period, and there were some extenuating circumstances when the crime occurred. So there is some leeway, but very rarely granted for crimes that took place before 1990. After 1990, the law is pretty clear that people with this type of crimes will not be allowed to naturalize. There is a second category of crimes which are of lesser degree than the ones enumerated short while ago. And these are the crimes that result on a conditional bar. And what conditional bar means is if these types of crimes were committed during the 5 or 3 year statutory period, the person is barred from getting a citizenship, U.S. citizenship. So what are these crimes? One of the most common type of crimes is the so-called crimes involving moral turpitude. So, for example, an aggravated battery will be a crime involving moral turpitude, whereas simple assault may not be considered crime involving moral turpitude, or otherwise they call it CIMT. Crimes against the property, for example, larceny, theft, those are generally considered crimes involving moral turpitude. Sex offenses, family crimes such as spousal abuse, abuse of a domestic partner, those are also considered generally as crimes involving moral turpitude. And crimes against the government, such as bribery of a government official, for example. So other types of conditional bars may result from multiple crimes when they are not crimes involving moral turpitude, but there are multiple crimes and the aggregate sentence was over 5 years. Other types of crimes that may result in conditional bar are drug offenses. It includes also such offenses as polygamy, for example, gambling offenses, illegal gambling, people who are habitual drunkards. This is, of course, probably not a crime, but it's still considered a sign of a person not having a good moral character. Other offenses include, for example, not paying child support, court-ordered child support, or alimony. Also, one of the conditional bars that may result in denial of citizenship is, for example, an adultery, where the fact of adultery results in the failure of the marriage. And there is another category, so-called the unlawful acts. These are not necessarily crimes, but again, they are considered by the government to be actions that a person with good moral character should have not taken, such as not paying taxes or voting in federal elections or state elections, for that matter, without being a U.S. citizen. So these conditional bars affect the individual if they were committed within that 5 or 3 year statutory period. If these crimes were committed outside of statutory period, then they cannot be used to bar a granting of a citizenship. However, in some circumstances, still the adjudicating officer can look at the totality of the circumstances and to determine whether in his or her discretion, the citizenship application will be granted. As an example, if the action took place outside of statutory period, but there is a pattern of the person doing the same action multiple times, or there is no evidence that the person has rehabilitated, or the action took place very close to the 5 year statutory period, then the officer may decide not to grant the citizenship by looking at the overall individual circumstances of the specific case. These are the permanent bars and the conditional bars that may result in the denial of citizenship based on the commission of crimes or certain unlawful acts. What this conditional bars on determination of good moral character mean is the naturalization application will be denied. However, there is also the risk that the person, by filing an application to get citizenship, may put himself or herself into further jeopardy because certain crimes are also crimes that may result in deportation of the individual. Very often, whether through mistake, inadvertence, or oversight, after commission of certain crimes, the immigration authorities do not get hold of the individual to start removal proceedings. For example, if a person commits a crime, a single crime of involving moral turpitude, that person may be deportable. And they need to go in front of the judge, and if there are any other ways to ask the judge to waive those the effects of that crime, then they can remain in the country. But the bottom line is, after a person commits a crime that is a deportable offense, that person has to go in front of the judge. In some situations it never happens, as I said, whether by mistake, inadvertence, or oversight, that doesn't happen, and a person thinking that, well, they were able to leave that in the past, now they decide to go and file for immigration, for citizenship. They even think, oh, I know about the 5-year statutory period, I'll wait, let's say 7-10 years, and then after that I'll go and file for my citizenship. And what happens typically, the person goes to his or her interview, the officer then refers the case to immigration court. Even though the 5-year statutory period is over and the crime was outside that period, the officer will nevertheless refer the case to immigration court because the applicant was deportable, and they will not entertain the naturalization application. As a matter of fact, they are barred from adjudicating application when the person is in naturalization application, when the person is in removal proceedings. So the person has to go back, has to go to see a judge and try to either keep his or her green card, or perhaps apply for a new green card through different means, other means different from what they had obtained the green card to begin with. There are, of course, exceptions, as in to any rule, and to this rule as well. For example, if there is a crime involving moral turpitude, and that crime is, for example, a petty larceny, petty theft, the immigration authorities will waive that one crime of petty offense crime, such as petty theft, and they will not consider that, or they will not count that towards the person's determination of good moral character, whether it's within the statutory period or whether it's for the discretionary authority, whether to send the person to immigration court. There are other exceptions as well. The most important point is once there is a criminal conviction, no matter how small, no matter how small of an offense it was, it is best that the person reviews his file with competent counsel to ensure that the offense itself, first of all, is not going to be a bar for the citizenship, and second of all, is not going to further jeopardize the person and put their green card at risk by filing the application for naturalization. I hope this information has been useful, and I will see you next week.